The Federal Competition and Consumer Protection Commission was originally the Consumer Protection Council, and it only had one mandate, which was consumer protection. However, in 2019, with the presidential accent to the bill, the then bill, and now the Federal Competition and Consumer Protection Act, we now have two mandates, not just consumer protection, but also competition. And you will find in the course of this discussion why that became an issue at some point in the conversation. And you've heard Professor Claudia also talk about the intersection between competition and consumer protection and all of that. But besides the FCCPA, we also have the Constitution, and that's the grundam. That's the most fundamental law in the land for which the FCCPA draws its legitimacy. The Constitution, I believe is Section 37, and makes it very clear that Nigerian data subjects have a fundamental right to privacy. Their rights to self-determine how their data is collected, is used and democratized. We also have the Nigerian, at the time when this investigation started, we didn't have the Nigerian Data Protection Act, which we now do. But we had the Nigerian Data Protection Regulation, and that was also, again, responsible for the regulation of how data was democratized and the portability of data. So in terms of scope and jurisdiction of the Federal Competition and Consumer Protection Commission, Section 2 is very clear. As long as it is a commercial activity that has effects in the Nigerian market, the jurisdiction of the FCCPC will apply. We also have a Section 17 that allows the Commission administer and enforce any law that borders on consumer protection and competition. And with respect to consumer protection and competition, and subject only to the Constitution, the supremacy of the Federal Competition and Consumer Protection Act is established. So that's the legal framework, and that provides the legal basis for which we're able to look into this